Hey everybody, so today what I'm going to do is do a bit of a deep dive into a very important case that happened in relation to the Brehon Law back in 1608. The name of that case was the Case of Tanistry. This, in my opinion, is a very important part of Irish history. It's not very well known, so for that reason what I'm going to do is I'm going to read through the entire document. Now there's quite a lot of pages in this. I will try to read it clearly, and maybe I will make some little tangents here and there just to add clarification and more information. Before we jump into it, I think it's a good idea to talk about what was Tanistry and what is a Taoiseach. So in early Ireland, we had a system of, let's say, kingship that was not based on the same models of continental Europe, which is called primogeniture. In the primogeniture system, such as with the English crown, how it worked was that the eldest born male, the primogeniture, would automatically inherit the right to be king, the title of king, from the father when the father passed away. In Ireland, it didn't work that way. The king or the chieftain, who we call the Taoiseach or a Rí, was actually elected from among all the eligible heirs who had a kind of a claim, or they were of noble quality, which meant that they could be elected from among the wider tribe to be the representative of the tribe, the chieftain. Now, in order to avoid disputes, familial disputes and feuds, the custom of Tanistry, which was naming the Taoiseach, Taoiseach meaning the second in command. The custom of Tanistry was practiced in Ireland, which would mean that the successor to the chieftain was always going to be named and known about during the life of the chieftain, so not after they died. And it wasn't a case that it would always be the firstborn male son of the living chieftain. It could have been anybody from within, as I said, the eligible, what was known as the Rí Downa, the kingly material. Anybody who was eligible within the tribe could be potentially elected or selected by the tribe's people to be the chieftain and therefore the successor. So the case of Tanistry is a really interesting case. It's studied in legal context. It's studied in regards to anthropology, the history of colonialism and things like this. I think it's important to point out that generally when we're speaking of the age of imperialism, it happened a little bit later. And when I was studying to do my master's in politics, philosophy and economics, we had a class called the United Kingdom on the Map. And this class was all about the British Empire. And imagine my surprise, I was studying in Prague. Imagine my surprise when we went to the first class and Ireland wasn't even mentioned. Ireland wasn't even a part of this class, and I had to raise my hand and ask the professor, aren't we forgetting a really important part of history here? Like, you're just totally forgetting that the English crown was present in Ireland for hundreds of years before the age of imperialism happened. So this is an interesting case for a lot of reasons. I'm going to start going through the document now. There's, as I said, quite a lot of info in here, so please stick with me because I'm sure you're really going to learn something interesting here. So the case of Tanistry is a case that went before the Irish Court of King's Bench on referral from the Presidency Court of Munster in 1608. It's reported by Davis in the report 2880 ER 516. It deals with topics such as the rights of king on conquest of a new realm, the rights of the inhabitants on conquest, the effect of introduction of common law into Ireland, the extinguishment of Brehon Law, the recognition of Tanistry as local custom, the rules on recognition of custom, extinguishment of custom, and extinguishment of Tanistry. Now, I said I might go on tangents here and there and just take a little aside to go into more details. But before I go into like the bulk of this document, what I just want to stress here is that this case was so important around the idea of title and succession and custom. As a little prelude here, that the Tudor conquest of Ireland had a policy with the Irish chieftains which was known as surrender and regrant. So what that meant was that the Irish chieftains would surrender their tribal lands on behalf of their people, that they're holding in trust for their people. They would surrender that to the British Crown, and in exchange, they would be regranted a British title. Why? Because prior to this, if, let's say, the British Crown made an agreement with a chieftain, and we don't have primogeniture, and that chieftain dies, and a new chieftain is selected from among the tribe, how can they be bound by any contract here? In other words, the title, the right to rule, was not invested in a single bloodline. That's maybe a single bloodline, but not in a straight patrilineal line of descent. So this is really important. And this is why the British conquest of Ireland couldn't really have been successful unless they could establish their system of primogeniture and do away with the custom of Tanistry. In this sense, when the title, the newly created British title, was bestowed on a chieftain who now became an earl or a lord or something like that within the British system, it meant that upon their death, it would go to the eldest son, and the title remained in place. It just passed from one man to the next. So in that sense, the agreement stayed in place. Okay, the agreement that was attached to the title. So the introduction. As arguably the first English colony, Ireland was key in the development of a jurisprudence of colonial expansion, the effects of which can be seen in the legal rules applied to the settlement of Australia. The case of Tanistry, referred to briefly by Justice Brennan in Mabo versus the State of Queensland No. 2 in 1992, is perhaps the first case of which we have some report to consider the relationship of the common law to a foreign legal system in the context of a colonial situation. The case of Tanistry also forms the link between the early exercises of jurisdiction by the common law over custom in a domestic setting and the eventual recognition of native title, in part by transferring the rules on recognition of common law custom in an English domestic setting to the recognition of custom in a colonial context. So a short historical background on the case here. It was generally conceded that prior to what is known as the reconquest of Ireland or the Tudor conquest of Ireland, British control of Ireland had been limited. Effective English control penetrated to only a handful of port towns and a 50-mile radius around Dublin, an area that was known as the Pale. Davies makes it clear that in many parts of Ireland, Brehon law remained largely operative after the arrival of the English. The English described Brehon law as the, quote, common law of the Irishry, end quote. This promoted a view of Brehon law as a national law, such as the rapidly emerging common law of the period aspired to be in England. Originally, however, the word Brehon was simply an anglicisation of the Irish brihv, or judge, and did not define the nature of the law administered by such a man. According to Nichols, Brehons settled legal disputes as arbiters rather than officials of the court. Their decisions were based on the principle of arriving at a compromise rather than necessarily on the basis of enforcing a known legal rule. Very important distinction here between the Brehon law and the common law. Despite the Treaty of Mellifont on the 4th of April 1603, which officially finalised the Tudor conquest of Ireland, it was clear by 1606 that the Ulster nobles were still relying on the possession of vast tracts of land in order to enhance their power and authority against that of the British Crown. In particular, it appeared to the Crown that they were relying on the customs of Tanistry and Gavelkind. Tanistry was the name given by contemporary English observers to the practice under which Irish succession evolved through the male line or agnatic descendants of a common grandfather to the most worthy male member of the extended kin group. The result of this was not infrequent strife between rival family factions. The Irish system of individual land tenure was known to the English as Gavelkind, so named because it reminded the Norman settlers of a local feudal system in Kent called Gavelkind. Under this system, at least as it was understood by Sir John Davies, ultimate proprietorship of land lay in the extended kin group, and the allocation of individual allotments of land was temporary and subject to periodic redistribution. Thus, Tanistry and Gavelkind were construed by Davies and other English jurists as constituting a system of law which lay outside the jurisdiction of royal writ. As such, they lay in the way of assimilation of the autonomous Gaelic lordships by providing a power base outside the jurisdiction of the common law. In order to assert full authority over Ireland, therefore, it was necessary to prescribe Gaelic forms of land tenure. As a result, in 1606, by an extrajudicial resolution of the Privy Council, the customs of Tanistry and Gavelkind were adjudged to be utterly void in law, with the result that they were to be shortly avoided and extinguished either by surrender or resumption of all the lands so holden. Extrajudicial resolutions, that is, those collective decisions made by the English or Irish judiciary in conclave, were used during the first decade of the 16th century in Ireland, and to a lesser extent in England, in order to establish policy guidelines in a variety of constitutionally and politically significant cases. Such decisions were intended to establish precedents which would compel other tribunals to follow their lead in cases involving similar disputes. In 1608, the case known as the Case of Tanistry was referred to the Court of King's Bench from the Presidency Court of Munster, although the issue of Tanistry had supposedly been dealt with by extrajudicial resolution. This case provided the Crown with an opportunity to confirm the abolition of Tanistry by a trial before a jury on the issue. A note on the case reporting. The case was reported by Sir John Davies, Solicitor General, later Attorney General for Ireland, who appeared on behalf of the defendant. There is no clear distinction made by Davies between the plaintiff's argument, the defendant's arguments, and the judgment. As the case was argued several times, the report of the judgment is a synthesis by Davies of several judgments by the Court of King's Bench. The facts and arguments. The case was an action for ejectment and involved a complicated set of land transfers based in turn on a complicated family tree. At its most basic, however, the case revolved around the question of which of two competing titles to a particular piece of land was better, that of the plaintiff, Murrow MacBrien, derived from the title of the Tanist, or that of the defendant, Donogh MacTaigh Callahan, derived from the title of the heir at common law. And this is a really important distinction to understand. This is what I was speaking about at the start. It's so important, I'm going to read it again. At its most basic, the case revolved around the question of which of two competing titles to a particular piece of land was better, that of the plaintiff, Murrow MacBrien, derived from the title of the Tanist, or that of the defendant, Donogh MacTaigh Callahan, derived from the title of the heir at common law, the English common law. The main legal issue in the case was the validity of the custom of Tanistry. This required the consideration of two interrelated questions. First, was the custom of Tanistry abolished by the introduction of the common law? And second, was the custom of Tanistry good at common law? In other words, did it meet the common law requirements by which the validity of customs generally at common law were decided? The jury had already issued a special verdict to the effect that the land in question lay in the county of Cork, and since time out of mind had been in the tenure and nature of Tanistry. The defendant contended that the introduction and establishment of the common law of England had abolished Tanistry on the basis that the custom of Tanistry was the common custom of the land of Ireland before the conquest, and therefore had been abolished by the establishment of another general law, that is the common law. Counsel for the plaintiff conceded this point. However, he maintained that despite this, particular customs might stand, just as, quote, the custom of Gavelkind in Kent and other customs in particular places in England remained after the Norman conquest, end quote. These customs could be established by recourse to the usual common law criteria used to determine the validity of local customs. The case proceeded on this basis. On the particular question of law at issue, it was held that the custom of Tanistry was void at common law. However, on the matter before the court, the judges never handed down a verdict. Rather, as is recorded on the final page of the judgment, after the case had been argued several times and had languished before the King's bench for 3 or 4 years, the parties came to an agreement to divide the land. So basically they settled outside of court. And what I find interesting about this, it's a shame that it wasn't finally resolved in the court, but it's interesting that it lasted for so long. As you see here, it says 3 or 4 years. I guess the exact time is not really known, but it was at least 3, maybe 4 years. And it was argued several times before the King's bench. Now we move on to the details of the case, and I must first say that it is written in a kind of Old English, so forgive me if I make some mistakes with the pronunciation here, but to recite the facts. Upon which one main question ariseth, viz. Whether the title of the heir at common law which the defendant had, or the title of the Tanist, which estate the lesser of the plaintiff had, should be preferred, as this case is. And in the discussing of the question, 3 principal points were moved and argued. The plaintiff argued as followed: whether the said custom of Tanistry was void or not in itself, or otherwise abolished by the introduction of the common law of England. 2. Admitting that it was a good custom and not abolished by the common law, whether it be discontinued and destroyed by the feoffment which created and limited an estate tail in the land according to the course of the common law, so as that it shall not be reduced to the course of Tanistry when the estate tail is determined. 3. As to the first point, it was objective by the counsel of the plaintiff that the said custom of Tanistry, as it is found, is good by the rules of the common law. For 3 things ought to concur to make a custom good: antiquity, continuance, and reason. And it is expressly found that this custom is ancient beyond time of memory and continual time out of mind, and therefore, if it be reasonable also, it had all the qualities of a good custom, and certainly this custom, which giveth the land to the oldest and the most worthy man of the blood and surname of him who died, is very reasonable in this kingdom, because he can better manure the land and defend it than an infant or a woman, and the continuance of the land in the blood and surname is a good consideration to raise and use. Then it's quoted here, I believe, Ploud, Com 305, Bainton's case, where the dignity of the heir male is expressed in several cases. Wherefore, this custom doth not want reason to support it. And in Lit. Lib. No. 1, section 80, puts this rule, to wit, that in diverse seigneuries and diverse manors, there are several and diverse customs as to take lands and tenements, and as to plead, and as to other things, and that whatsoever is not against reason may well be admitted and allowed. I know the English here is not very pleasant to our ear, but please stick with me through this. I'll do my best. And although this custom should be repugnant to the rule of the common law, this doth not prove it to be unreasonable, for the customs of Borough English and of Gavelkind are contrary to the common law in point of descent of inheritance, and yet are approved as reasonable customs. So the custom of turning the plough upon the headland of another, and of drying nets upon another's land, so that a feoffment with warranty made by a tenant in tail shall not be a discontinuance, contrary to the rule of law, and yet is a good custom, and several cases were put to that purpose. And as this custom is not void for want of reason, so at this point it seems like the custom of Tanistry has fulfilled the three requirements of a custom under the common law. It goes on, and as this custom is not void for want of reason, so it is not void for want of certainty. For the land shall descend to the oldest and most worthy. The oldest may be certainly known, but the most worthy seems to be uncertain. For who shall be the judge of that? Certainly the law, which is always certain and infallible in judgment, and the law will say that the oldest is the most worthy as well, in this case as other cases of this nature. And therefore, Lith saith, Lib 1, section 5, if there be three brothers, and the middle brother purchased lands, and died without issue, the eldest brother shall have the land by descent, because the eldest is most worthy of blood. And in the chapter of Remitter, section 659, he said, where a man has two titles to lands and tenements, viz., one more ancient and another later, the law will adjudge him by force of the more ancient title, because the ancient title is the more sure and more worthy title. But admitting that the affirmative part of the custom, viz., that the land shall descend to the oldest and most worthy man, etc., should be void, yet the negative part of the custom, viz., that the daughters shall not be inheritable, is good. For there are several good customs in the negative against the express maxims and rules of the common law, as that the wife shall not have dower or dowry, where she had received part of the money arising from the sale of the land. And the custom in Kent, that the lord shall not have the land by escheat, the father to the bough and the son to the plough, and the custom of which Kitchen speaks, that if a man marries a widow, she shall not have a dower. And then, if this part of the custom be good, judgment must be given against the defendant, because he derives his title from the daughter, who is the heir at common law. And this custom is not abolished by the introduction of the common law for diverse reasons. I'm just going to pause here to clarify what's happening. So we're analyzing the nature of the two titles, the two claims. And in the common law system, it's felt that the most worthy heir is the eldest male. Okay. The Irish system, the heir would be the one who is deemed to be most worthy from all of the eligible males within the kin group. Okay. What makes this case a little bit more complicated is that Callahan was claiming the right to title because he had married the woman who was inheriting that title. She was, I believe, the only child of the landowner. And so it's interesting here because in the English common law, they didn't really treat women very well, and especially when it came to title and ownership. So this complicates the case a little bit further in the fact that the individual, Callahan, who was claiming the title, was claiming it through marriage to a woman who was technically inheriting that title. So that's just a little point of clarification I want to make there. So it goes on, and this custom is not abolished by the introduction of the common law for diverse reasons. Number one, because it is a reasonable custom and agreeable to the rules of the common law, as is before shown, and for this reason it is resolved in 21 L. Dyer, page 363, that the custom of the town of Denbigh in Wales, that a femme covert with her husband may aliene her land by surrender and examination in court here, and that shall bind the wife and her heirs as a fine, is not taken away by the statute of, maybe it's Helen, I don't know, the statute of Hen, number 8, although that act introduces the common law in Wales, as appears by the title of it, for laws and justice to be administered in Wales in like force as in the realm of England. Number 2, although the Brehon Law, which was the common law of the Irish before the conquest, be abolished by the establishment of the common law of England, which was justly done according to the law of nations, notwithstanding that this was a Christian kingdom, as appears in Calvin's case, yet the particular customs may stand as the custom of Gavelkind in Kent, and other customs, in particular in places in England, remained after the Norman conquest. 3. It may be collected by the judgment of Parliament that this custom of Tanistry was not taken away by the common law, because by this act the pretended lords, gentlemen, and freeholders of the Irishry, and degenerate men of English name, holding their lands by Irish custom, have power of surrendering their lands to the Queen, and have taken estates by letters patent, which shall be good and effectual in law against all persons except those who have estate, title, or right to the said land by due course of the common law. So what we see happening here is sort of a comparison to similar customs that existed, in this case in Wales, and seemingly were allowed to continue even after the introduction of the common law in Wales. And the question is, well then, why couldn't they continue in Ireland when the Brehon Law was replaced or extinguished? And part of the argument here is that presumably this custom of Tanistry must have continued, otherwise how could those who held the title to the land under the law of Tanistry ever be how could it ever be possible for them to sign over the ownership or surrender and regrant that land under a British title? As to the second point, it was objected that the gift entail, the remainder to the right heir of the donor, did not destroy this custom for two reasons. So I believe we're talking about the Welsh custom here again. And they're saying, well, it doesn't apply here. 1, because he who had land of the tenure and nature of Tanistry had not such an estate as that he can aliene his land in perpetuity, but only during his life, and his estate is qualified like the estate of a parson of prebendary. I don't even know what that means. So that the fee simple is in abeyance. Number 2, because this custom is inherent in the land and runs with it, and cannot be extinguished by any alienation, but continues in any person's hands, as well as in the possession of the king as of a subject, as the customs of Borough English and Gavelkind. For if land in Borough English be given in tail, the younger son shall have a formidon, and there's a case here, a case number here. And if the land in Gavelkind be given in tail, the remainder to the right heirs of the donor, as this case is, as well the remainder as to the possession shall go to their heirs by custom, and not to their heirs at common law. And although it be held in 37 Hen number 8 or page 8, I don't know what the abbreviation is, but it says this is another case that's being referred to here, that if land in Gavelkind be leased for life, remainder to the right heirs of is, if is hath 4 sons and die, the remainder shall go to the eldest, for he is the right heir, and that is a name of purchase. Yet that differs from our case, for the remainder limited of the right heirs of the donor is only a reversion, and the heir shall have it by descent, and that the possession of the kind does not extinguish such custom. And then it refers to another case. I did say at the start that this is quite complicated. So now let's look at how the defendant replied to these initial claims. And as to the first point, touching the custom, it was first said that a custom in the intendment of law is such a usage as has obtained the force of law, and is in truth a binding law to such particular place, persons, or things as it concerns. And such custom cannot be established by the king's grant, nor by act of parliament, but it is jus non scriptum. And that means like it's like a right that's not written down. Jus relating to like jurisprudence, non scriptum, not written, and made by the people only of such place where the custom runs. This is really important because what we're seeing here is kind of an insight into the nature of law itself. And it's saying that, a custom that is treated as having the force of law in a particular place or in relation to particular persons or things should and is generally treated as law. For where the people find any act to be good and beneficial and apt and agreeable to their nature and disposition, they use and practice it from time to time. And so, by frequent iteration and repetition of the act, a custom is formed, and being used time out of mind, it obtains the force of law. And this, to make another little tangent here, I've said many times, is kind of like the essence of the nature of the Brehon Law. You've seen, we've heard this phrase already, time out of mind, a few times in this case, something being around since time immemorial. This is why the Brehon laws were often described as being as old as the rocks or as old as the hills themselves. And this is where we get the nature of the polycentric law. This is not the type of law that the king has a whim and decides to enact a rule, and because I'm talking about the British king here and the continental nature of monarchy, they can just enact a law, and because it is the spoken word of the king or the written word of the king, it is, on the face of it, considered a law. Well, that wasn't the case in early Ireland and in other pre-colonial systems, where it was actually the custom, the behavior of the people, and how they decided, using their reason and good judgment in a way that suited their nature, decided how things should be done in order to produce a, let's say, peaceful or prosperous or basically just a functioning society. So first you have, I guess, a habit, or you have a certain way of doing things emerges. That certain way of doing things, when it's seen to be beneficial, is repeated again and again and again, and it's repeated so frequently and for such a long period of time that it eventually acquires the force of law. So a custom becomes a norm, and the norm is, let's say, a type of behavior that can be expected among the members of that unit or society. And eventually that norm is treated as though it is law. On the note of something being around since time immemorial, well, that's interesting as well, because time immemorial just meant that this is the way things had been done for as long as anybody right now can remember. So generally speaking, you could say that was around 90, maybe 100 years, because it was kind of once the third generation, once that custom had been around for the third generation, and all of the people who were living at the time the custom was formed have now passed away. Therefore, the living people could say that this custom has been the way it is since time immemorial. So the Irish liked to be poetic and say it was old as the rocks, and in some cases it was very, very old. But in a practical sense, time immemorial could just be around 90 to 100 years. So where am I? For where the people find any act to be good and beneficial and apt and agreeable to their nature and disposition, they use and practice it from time to time, and so by frequent iteration and repetition of the act, a custom is formed, and being used time out of mind, it obtains the force of law. And so the rule number 44, I believe, of Edward 3:19 is true, that no law binds the people, only that which is made by consent of the people. For consent may be expressed as well by deed as by word, and that which is expressed by deed is stronger than that which is expressed by word. and that which is expressed by several and continual acts of the same kind is a custom. And so briefly, custom is a reasonable act reiterated, multiplied, and continued by the people time out of mind. And this is the definition of custom, which had the virtue and force of law. This is a very powerful paragraph for reasons that I probably don't have time to go into here. But there is a maxim in our law which says contract makes the law. And in a philosophical sense, and in a very true sense, in a logical sense, no individual can be bound to do something that they have not previously agreed to do. In other words, contract, your agreement, is what creates the sense of obligation, the sense of duty, the pressure for performance, let's say. Consent makes the law. This is essentially what the Rule 44 of Edward 319 says. And I'm going to read it again because it's so important. The rule is true that no law binds the people, only that which is made by consent of the people. For consent may be expressed as well by deed as by word, and that which is expressed by deed is stronger than that which is expressed by word, and that which is expressed by several and continual acts of the same kind is a custom. And so briefly, custom is a reasonable act reiterated, multiplied, and continued by the people time out of mind. And this is the definition of custom, which has the virtue and the force of law. If you're still with me at this point in the video, thank you. I did promise you it was going to be interesting. Secondly, it was said that such custom ought to have 4 inseparable qualities. 1, it ought to have reasonable commencement. 2, it ought to be certain and not ambiguous. 3, it ought to have uninterrupted continuance time out of mind. 4, it ought to be submitted to the prerogative of the kind and not exalted above it. 1, the commencement of a custom. For every custom has a commencement, although the memory of a man does not extend to it, as the river Nile has a spring, although geographers cannot find it. Ought to be upon reasonable ground and cause. For if it was unreasonable in the original, no usage or continuance can make it good. But to distinguish what is an unreasonable custom and what not, these differences were put. Every custom is not unreasonable that is contrary to the particular rule or maxim of positive law. Yet a custom may be prejudicial to the interests of a particular person and reasonable also, where it is for the benefit of the commonwealth in general, as a custom to make bulwarks on the ground of another for the defence of the realm, and to pull down a house in a public fire, so to turn the plough on the headland of another in favour of husbandry, and to dry nets on the land of another in favour of tithing and navigation. But a custom which is contrary to the public good, which is the scope and general end of all laws, or injurious and prejudicial to the multitude, and beneficial only to some particular person, is repugnant to the law of reason, which is above all positive laws, and therefore cannot have a reasonable or lawful commencement, but is void ab initio, and no prescription of time can make it good. Do you hear that? The law of reason is above all positive laws and therefore cannot have a reasonable or lawful commencement. It is void ab initio. That means like from the beginning, on the face of it. And no prescription of time can make it good. So while it's important to have a aspect of continuance of time in relation to a custom, it's not that alone that makes the custom good or give it the force of law. It requires the law of reason. And even if there was a long-lasting quote-unquote custom, but it only was beneficial to some particular person and not the wider society, and that particular person could be the monarch or a member of the clergy, it's not enough to claim then that this is a good custom. On the second point, number 2, a custom ought to be certain. And there's a Latin sentence here which I'm not even going to try. For incerta pro mullies habentur and consuetudo exerta cause rationabili usitata privat communem legem. It wasn't too bad. It wasn't too bad. Here, 3 of the essential qualities of a custom are expressed, viz., certainty, reasonableness, and usage or continuance. In 13th, I believe it's like the 13th statute of Edward, number 3, or section 3, Vits dum fuit infra etatem. 3. A writ of dum fuit infra etatem was brought against an infant. The tenant pleads a custom that when an infant is of such an age that he can count or measure an ell of a cloth, his feoffment shall be good. This custom was adjudged void on account of the uncertainty. So it's pulling in, this is my side here, it's pulling in like an example of a custom where if an infant can count or measure the ell of a cloth, which I don't know what that is, his feoffment, which I believe is like his agreement to sell the land or to alienate his land, should be allowed, but this custom was judged void on account of the uncertainty. Then it's given the statute, another statute of Edward here, and I believe a case, Fitzbar, page 277. In trespass for trees taken away, the defendant pleads a custom that such one of the tenants of the manor as first comes to the place where, and so on, shall have all windfalls there. This custom is void also, for the uncertainty. And the reason alleged there is that this does not lie in prescription, which lies in the will of man, for the will of man is uncertain. In 42 Edward number 346, in Replevin, brought by the prioress of Shafton, the defendant vows as bailiff to the sheriff of Dorsetshire, who prescribes to hold his thorn in the place where, and so on, and to have from the third tenant a demi-mark or horse as a fee at each thorn. This prescription is held void for the uncertainty, for it is said that there also that this uncertainty lieth in the will of the donor, which is uncertain. I'm sorry, it's getting tough. And besides this, 2 reasons were given why an uncertain custom should be void. 1, because an uncertain thing cannot be continued time out of mind without interruption. And 2, because a man cannot prescribe in a thing which could not, at its commencement, be well granted. But an uncertain thing could never be well granted, and therefore a prescription of an uncertain thing is void also. I think this is just a very elaborate way of saying that certainty is important. Number 3, custom ought to have an uninterrupted continuance time out of mind. For if it be discontinued within the time of memory, the custom is gone. Custom ought to have an uninterrupted continuance time out of mind. For if it be discontinued within the time of memory, the custom is gone. As if a copyhold be leased by the lord of the manor for the life or for years, according to the course of the common law, it shall not be afterwards demised as a copyhold according to the custom. So this is important. I'm not 100% sure what a copyhold is. I believe it's some like right to access or use of land. And what it's saying is that if the common law approach is the legal basis for this transfer, well, then you cannot then rely on the later rely on the custom, because the custom has been discontinued by the fact that a new law has been used for that purpose. For as continuance makes a custom, discontinuance destroys it. 4. A custom which exalts itself on the king's prerogative is void also against the king. For prescription of time makes a custom, but nullus tempus occurrit regi. 49 Edward 3:3. The custom of London to make corporations is held void, for the king only can make them by his prerogative. Clearly, this is talking of a very particular time in the history of England and the British Crown. But here saying that London, the city of London, the county of London, is not able to make corporations is held void because only the king can make corporations by his prerogatives. And now we move on to the court's judgment. By these rules of customs in general, the particular custom of Tanistry was examined, and first it was resolved that this custom was unreasonable and void ab initio, for it is against the commonwealth, and goeth utterly in destruction of it. For a commonwealth cannot subsist without a certain ownership of land, or if the right of inheritance of land does not rest in some person. Pay attention to this. The custom of Tanistry was examined, and it was resolved that this custom was unreasonable and void ab initio, for it is against the commonwealth, and goes utterly in destruction of it. For a commonwealth cannot subsist without a certain owner of land, title, or if the right of inheritance of land does not rest in some person. I would just like to flesh this out a little bit and say, just think of taxation here. Think of the crown's prerogative and claim to land. If title is not clear, well then the ultimate claim over the land of the crown by the crown is also not clear. So it's held here that this is a complete kind of it's unreasonable, and it's the destruction of the commonwealth. For if men have not such an estate in their lands as their issue or cousins next of blood may inherit, so that they may know certainly for what person they travail and defraud their souls of pleasure, as Solomon said, they will never improve their land to the best use and profit, nor build houses of any value, nor give civil education to their children, but having respect to their present time only, will be utterly careless of their posterity. And this is the true cause of the barbarism and desolation which was in all the Irish counties where the custom of Tanistry was in use. Also, this has been the great cause of the continual felonies and treasons committed by the Irish in time heretofore. For when they knew that their wives were not to be endowed, nor their issue, children, inheritable to their lands, they committed such crimes with greater audacity, for from affection to their wives and children, men more eschew to commit felony, as Lit saith. Therefore this custom which lets the inheritance and the freehold also be in abeyance after the death of every tenant is unreasonable, and goes in destruction of the commonwealth. And therefore our law, although it suffers the fee simple in some cases to be in abeyance for a little time, yet it ought never to suffer the freehold to be in suspense, and therefore if a lease for years be made the remainder to the right heirs of is, the limitation of the remainder is void. And if the king's tenant dies without heir, or the king's donee entail dies without issue, the land is immediately in possession of the king without office to avoid this absurdity. If the king's tenant dies without heir, or the king's donee entail dies without issue, the land is immediately in the possession of the king without office to avoid this absurdity. What is the absurdity they're talking about here? Well, there's a maxim of law that the law abhors property in a vacuum. It's absurd that there might be some land out there that isn't clearly owned or held by somebody, and in that case, to avoid that absurdity, the possession rests immediately with the king. And for this reason, in 6th Edward 6 Dyer, page 71, land cannot be appendant to an office for life, but to an office of inheritance only. For if it were appendant to an office for life, a great inconvenience would ensure, as is there said, viz. The freehold would be in suspense after the death of the officer until a new officer were made or created. If the office did not descend unto the heir or to a man who had a perpetual succession by common law. And that is the most apt case in the law to be resembled to the case in question. Title, primogeniture. The idea that the inheritor of the land might not be known upon the death of the holder was considered absurd. And so having a title, Lord of whatever, and that title would, upon the death of the holder of title, automatically transfer to the next heir, the eldest born male, that would ensure that all of the rights and obligations attached to the title would transfer instantly, and there would be no suspension of ownership. For the custom of Tanistry, the oldest and the most worthy does not come in as heir, for heir is always the nearest of blood, but as a successor. Yet because he is not incorporated by the common law as a person, as a legal person, prebendary, and so on, he does not come in by course of perpetual succession, but as an officer for life only, and by election. But until election is made, the freehold of the land is in suspense, and the fee simple and inheritance is always in abeyance, and so no fee simple in actu at any time, contrary to the principle of the common law, that of every land there is a fee simple. This custom is also unreasonable for another reason, viz. Because this custom, as is found by the special verdict, that the land shall descend seniori e dignissimo viro, and so on, appears plainly to have commencement by the usurpati and tyranny of those who were most potent amongst them, as several customs, whereof mention is made before, adjudged in our books to be void in law, commenced by oppression and extortion of lords. For the ancient Brehon law was that such land should go to the oldest of the sept, which is another word for the tua, or the wider kin group, like a large kind of family tribal kin group. We called it a sept. That the land should go to the oldest of the sept, who was the true Tanist, and called in Latin fecundus, being the successor apparent. But the oldest was not always the most active, or had not the greatest number of followers, supporters. Another more powerful person by faction and strong hand intruded on the oldest, and procured himself to be elected as the most worthy in the opinion of the people. Yet it was bad in the commencement and bad in the continuance, for it was the cause of great effusion of blood and many other mischiefs. Let's disambiguate this a little bit. What it's saying is that On the face of it, the custom of Tanistry is not a good custom. Why? Because there is a true successor in the eyes of the common law, here referred to in Latin as the fecundus, which would be the oldest heir. Okay, but because this was a kind of a much wider group of people who had the rig downa, the kingly material, in order to potentially be elected, what this could do is it could allow another member of that company of the sept to rally support if they had a bigger, family clan within the sept, or use their strength and use their guile to secure his election to the chieftaincy over that of who the English common law deemed to be the one who was most suitable for the role. Also, the negative part of this custom is unreasonable, which utterly excludes the daughters from inheriting an estate of fee simple. For the Tanist, if he had any estate of inheritance, has a fee simple, for he has no particular estate's tail limited to him and their heirs male of his body. And it is against the nature of a fee simple to exclude the heir female. If the heir male fails, and therefore if a feoffment be made to is and his heirs, provided that he daughters shall not inherit, provided that their daughters shall not inherit, this is void proviso. And if the land be given to is and his heirs male, he had a fee simple, and the heir female shall inherit in default of an heir male. Why this is important in this context is, as I said before, the claimant under the common law title was claiming to have access to that title because his wife was the heir, as being the only daughter of the landowner who had deceased. So secondly, it was resolved that this custom was void for uncertainty, for whereby this custom the land is to descend signori e dignissimo viro sanguinis and cognominis of him who died deceased. 1, the person is uncertain, and 2, the estate is uncertain. So that some will say that the most learned and knowing man is the most worthy, some that the most valiant, some that the richest, and some that the most liberal. And so the multitude can never agree, and therefore the most powerful man was always preferred, which is contrary to all laws. But if it were referred to the judgment of the wisest man that ever was, to judge who is the worthiest man in any country, he would take a long time to deliberate in such a case. So what they're saying here is that you couldn't really say it was certain succession, because depending on who you asked, there would be different opinions about who would be the one who's like the best successor. Was it the one who was the bravest, the most valiant, the wisest, the richest, the kindest? And therefore, the conclusion drawn from this was that succession was uncertain. So it's a rebuttal of the principle of certainty that was given above. But it was said that the law will adjudge the oldest to be the most worthy. Certainly in cases of descent of inheritance, the law respects primogeniture, birthright, and proximity, and wholeness of blood, but gives no regard to the worthiness or sufficiency of the heir. And therefore the law casts the inheritance as well on an idiot or an infant as on a person of discretion. Wherefore this difference taken in Sir Hen Neville's case, reported in Ploughed Commentaries 379b, that an officer for life cannot assign over his office without special words in the grant, for the law intends him to be an officer of trust, and chosen for his knowledge and diligence, viz., for his worthiness. But an officer of inheritance may grant over his office, for the law doth not intend that the grant was made upon a confidence of the sufficiency of the officer, for it may descend to a woman, an infant, or an idiot, and therefore the law does not respect dignity of person in case of descent of inheritance. For although primogeniture, having a prerogative given to it by the law of God, by be preferred also in our law, and so the oldest be in some sense the most worthy. Yet by this custom the dignity is intended to be of another quality than seniority, viz., another virtue of merit in the person which must concur with the seniority, for otherwise the word seniori has been sufficient, and this word dignissimo would be idle. And therefore such limitation by prescription is void also according to the rule taken in 13 Henry, that's Henry, not Helen, Henry, I think it's the 13th statute of Henry, number 7, 16, section 16b. 2. The estate is uncertain, for every person who hath an estate of inheritance has it either in his natural or his political capacity. But a Tanist has not an estate of inheritance in his natural capacity, because the oldest and most worthy does not take as heir, for the most worthy comes by election and not as heir. And the Tanist has not an inheritance by succession in a politic capacity, because he is not incorporate by the common law as a person, prebendary, and so on. And if he has only an estate for life, so when he dies he loses the title, it cannot descend. And so he has no estate whereof the law can take notice, and by consequence the uncertainty of his estate make it void in the law. Thirdly, it was resolved that this custom was interrupted and destroyed in the land when Donogh Taigh executed an estate tale of it, according to the course of the common law. For there is a difference where the custom runs with the seigneury and where it runs with the tenancy. For where it runs with the tenancy, it shall not be destroyed by the conveyance according to the custom of the common law, as if a fine be levied on land held in Gavelkind, although the course of inheritance be altered and made descendable to the heir at common law. Yet it was agreed by the court here that the custom was not altered, and so it was held of land in Borough English, number 2 of Elizabeth, reported in Dyer 179b. But this land in question is parcel for the domain of the chieftain or lord, or public Callahan, for the lands only which go with the chiefries are of the tenure and nature of Tanistry, and therefore like copyhold land, which is parcel of the domain of the lord, and if the lord executes an estate of it, according to the course of the common law, the custom is gone forever. So how I understand this is that the problem here is that even though there are lands that are given to the chief or the Tanist, they're never really in the common law sense like owned by those people. It's just a parcel of land that is attached to the chieftaincy, but not necessarily a legal title, as the English common law understands legal title. Also, this custom of Tanistry is not inherent in the land as the custom of Gavelkind or Borough English, but it is rather a personal custom which goes with the person of the oldest and most worthy. Therefore, when the land is once conveyed to another person, viz. The heir at common law, the custom is gone forever. So as soon as the land descends to the person who is considered the true heir at common law, this custom of Tanistry must be presumed to be gone forever. Lastly, this custom of Tanistry must be void against the king as being prejudicial to his profit and prerogative, for where all lands are held mediately or immediately of the king, by his custom the king would lose all the benefit of seigneury paramount in this land, which was quasi in manu mortua, of which the king can never have wardship or escheat or any manner of service, testifying his being the lord of it. And lit section 138 says that it would be inconvenient and against reason that anyone should be tenant to another of an estate in inheritance, and yet the lord have no manner of service from him. Tax. And for this reason the custom of Kent, which is Gavelkind here, the father to the bough the son to the plough, extends only to felony and not to treason. For there the king shall have his escheat. King has access to the land, rights over the land. This is what it was really all about. So a prescription to have sanctuary for treason is void, and therefore, although such Tanist had not an estate of inheritance by the custom, yet if he had been attainted of treason, the course of the exchequer here had always been to seize the lands as forfeited or escheated to the crown, notwithstanding this custom of Tanistry. But admitting that this custom had not been void in itself, yet the introduction and establishment of the common law of England had abolished it, for this custom of Tanistry was the common custom of the land of Ireland before the conquest, and generally used in all the Irish countries, and in the same nature and form as is found here, and therefore it must of necessity be abolished by the establishment of another general law in the same point. But as to the introduction of the common law of England into this kingdom of Ireland, it is to be observed that as this island was not fully conquered and reduced to subjection of the crown of England all at one time, but by parcels and in several ages, so the common law of England was not communicated to all inhabitants simul and semel, I guess means simultaneously, but from time to time, and to special persons and families of the Irishry, to whom the king was pleased to grant the benefit and protection of his laws. It is manifest by all the ancient records of this kingdom that the common law of England was only put in execution in that part of Ireland which was reduced and divided into counties and possessed by English colonies, which were not reduced into counties until the time of Queen Mary and Queen Elizabeth, and yet were in extent of ground more than two-third parts of this island. And therefore it was impossible that the common law of England could be executed in these countries or territories, for the law cannot be put in execution where breve domini regis non curit. I think it means like you can't put the laws into execution in a place where the king is not present, or the authority of the king is not present. And the king's writ cannot run. But where there is a county and a sheriff or other ministers of the law to serve and return the king's writs. And for this cause it appears by the ancient records that the mere Irish were out of the protection of the king. For Lit section 199 says that the king's law and the king's writs are things by which a man is protected and aided, and so during the time that a man is out of the king's protection, he is out of help or protection by the king's law or the king's writs. And the mere Irishry had not the benefit of the law of England without special charters of the kings to enable them. The court outlined the legal history of the English colonization of Ireland and concluded on the law as follows. And as to the land in question, it lies in the county of Cork, which is one of the ancient counties made by King John, and in which the common law of England has had its course for the space of 150 years at least after the conquest. Wherefore, although by the incursion of the Irishry, the course of the common law of England was interrupted and discontinued in this county for a long space of time, yet the execution of the common law being revived and restored, the custom of Tanistry and all other Irish customs not agreeable to the rules of the common law are annulled and abolished, as they were by the first introduction of the law of England in this country. And although this custom of Tanistry has been the custom of a particular place only, yet being repugnant to the rules of the common law, it was abolished by the introduction and establishment of the common law in this kingdom, and it is not like the case of Wales in Dyer, page 21, Elizabeth section 363b, where the particular custom of Denby continues. Notwithstanding the statute which establishes the common law in Wales, for the intent of the makers of that statute appears to be that the customs of Wales, agreeable to any customs in England, should be preserved. For by the same statute it is provided that a commission should issue to examine the Welsh customs, and that those which should be found reasonable upon certificate of the commissioners should be allowed. Also, this custom cannot be resembled to the custom of gavelkind in Kent, which had continuance after the Norman conquest. For the common law of England was not introduced by the conqueror, as has been observed and proved very learnedly by Lord Coke in preface to the third part of his reports. Lastly, where it was objected by one of the counsel for the plaintiff that Queen Elizabeth should be said to be in possession of this land by virtue of the first conquest of Ireland against Donna MacTaigh O'Callaghan de Fiofer, who cannot derive any title to this land from the crown, and therefore his feoffment, by which the defendant claimed, was void, being made by an intruder upon the possession of the Queen. It was resolved against this objection that Queen Elizabeth shall not be said to be in actual possession of this land by virtue of the first conquest. If it does not appear by some record that the first conquest had seized this land at the time of the conquest and appropriated it particularly to himself as parcel of his proper domain. For the kings of England have always claimed and had within their dominions a royal monarchy, and not despotic monarchy or tyranny. And under a royal monarchy, the subjects are freemen and have property in their goods, and a freehold and inheritance in their goods, and a freehold and inheritance in their lands. But under a despotic monarchy or tyranny, they are all as villains or slaves and proprietors of nothing but at the will of their grand seigneur or tyrant, as in Turkey and Muscovy. And therefore, when such a royal monarch, who will govern his subjects by a just and positive law, had made a new conquest of a realm, although in fact he had the lordship paramount of all the lands within such realm, so that these are all held of him, mediate, vel, immediate, and he had also the possession of all the lands which he willeth actually to seize and retain in his own hands for his profit or pleasure, and may also by his grants distribute such portions as he pleaseth to his servants and warriors, or to such colonies as he will plant immediately upon the conquest, as the ancient Romans upon their conquest used to appropriate the seventh part of the territory conquered for the plantation of their colonies, and the Vandals in Italy took their third part. Yet Sir James Leigh, Chief Justice, said that if such conqueror receiveth any of the natives or ancient inhabitants into his protection, and avoweth them for his subjects, and permitteth them to continue their possessions, and to remain in his peace and allegiance, their heirs shall be adjudged in by good title, without grant or confirmation of the conqueror, and shall enjoy their lands according to the rules of the law which the conqueror had allowed or established. If they will not submit themselves to it, and hold their lands according to the rules of it, and not otherwise. What followed was a short discussion on the Norman conquest and the rights of William the Conqueror. Sir John Davies then concluded his report as follows. This case depended in the King's Bench for the space of 3 or 4 years, and was argued several times, and the justices at several times delivered their opinions in the several points aforesaid. But afterwards, Sir Humphrey Winch being Chief Justice, the parties with leave of the court came to an agreement by which a reasonable division was made of this territory amongst them, in which division the castle and land in question, amongst others, were allotted to Cahir O'Callaghan, the defendant, and now besides their mutual assurances, they have obtained several grants from the King by virtue of a commission for strengthening defective titles. And so this country is well settled. Bolton, Recorder of Dublin, and John Meade whereof counsel with the plaintiff and the Attorney General with the defendant. And that brings us to the end of the case. I need to take a break after that, and I might come back with more information, or I might just wrap it up there. But if you stuck with me for this long through the video, thank you very much. I know it was long and a little bit complicated, but I hope that I was able to emphasize some of the key points about this case. I'm really curious to know what you thought as I was reading through this. Maybe some ideas came to you, maybe some notions about like this conflict between the Irish and English legal systems came to mind. Maybe some ideas around title and primogeniture and how did this compare to the custom of Tanistry that we had in Ireland. This is something that I think is incredibly important. I would like to do more research on this, but for now, I think it was just beneficial to be able to deliver this content to you, to lay the foundation of a really important aspect in Irish history, a case, a defining case in the Brehon Law and the abolition of the Brehon Law and the final extinguishment of the Brehon Law. So please let me know what you think about this video. Let me know what you think about this content. You can leave comments below in this chat on YouTube. You can email me, kev@brehonacademy.org. You can reach out to me on Facebook as well by going to the Brehon Academy page. But this is, I have my background, I have a degree in law. It's been a while, since I was studying that. So a little bit rusty on how some of these case reports should be cited. But I learned about this case many, many years ago, and I remember reading about it and just having a sense of how profound this information is in relation to how customs are formed, in relation to legal title, in relation to the legal person, and what it is to be a free man in the legal sense. So let's open the discussion. I'm really curious to hear what you have to say about this. Any questions, any discussion that you have at all, please reach out to me and we can continue the conversation. I'm going to wrap this up now because it was long and I need to take a break. So thank you so much for sticking with me to the end of this video, and keep an eye on all of our channels, the brehonacademy.org on brehonacademy.org, Brehon Academy on Facebook, on Twitter, and of course on YouTube, where I'm putting out most of the video content. Thank you for watching.